You are watching PR English Shorthand Dictations YouTube channel.
This is English Shorthand dictation number 391 and the dictation speed is 100 words per minute. Ready? Start. The learned counsel appearing for the appellant has taken us through the notes of evidence of material prosecution, witnesses, and other documents on record of the trial court. His submission is that last seen together is a very weak circumstance, as there is evidence on record to show that the appellant and the deceased were related. Very often they used to consume liquor together. He submitted that the recovery of the knife at the appellant's instance had not been proved. He submitted that even the existence of motive has not been pleaded and proved by the prosecution. He also submitted that if the oral evidence of PW7 and PW15 is considered together, the theory that the death occurred due to an accident of motorcycle cannot be ruled out. Therefore, the benefit of the doubt must be extended to the appellant. He submitted that every circumstance constituting a chain of circumstances has not been established. The learned counsel appearing for the state supported the impugned judgment. She submitted that the dead body of the deceased was found within a few hours from the time at which the appellant and the deceased were last seen together. She submitted that recovery of the weapon used by the appellant to attack the deceased had been duly proved, and all circumstances forming part of the chain of circumstances have been established. We have carefully perused the evidence of PW2, who deposed that on 29th September 1993 till 9 p.m., the appellant and the deceased consumed liquor in his house. He deposed that the appellant and deceased left his house after consuming liquor. He stated that the appellant and the deceased had gone towards Mango Orchard. The body of the deceased was recovered on the next day. In the cross examination, the PW2 stated that 2 to 4 times the appellant and the deceased had come to his place to drink liquor. He stated that the deceased used to consume a lot of liquor. PW6 Srimati Anjana Devi is the wife of the deceased, who deposed that the appellant came to her house and gave a currency note of rupees 50 to the deceased and forcibly took him for drinking. After that, the deceased did not come back. She stated that she deputed her elder son to the appellant's house, where the sister in law of the appellant informed the elder son of the deceased that the appellant was sleeping in the house. Thereafter, the appellant himself visited the house of PW6 and enquired whether his brother in law had come back. She deposed that at 12:30 p.m., one Raju informed her that the dead body of her husband had been found. She admitted that her husband used to drink alcohol occasionally. Sometimes he used to get drunk and people used to bring him back home. She stated that when her husband went with the appellant, she knew that they were going to drink liquor. PW7 stated that the deceased was his nephew. In the cross examination, he accepted that the deceased and appellant always used to be together. Thus, this was not the first occasion when the deceased and the appellant went together to consume liquor. Apart from being closely related, they had a close contact and they used to be together for drinking. The prosecution has not come out with a case that there was some motive on the part of the appellant for killing the deceased. Neither PW2 nor PW6 stated that on 29th September 1993 there was any dispute or altercation between the appellant and the deceased. Thus, the deceased being in company of the appellant on 29th September 1993 was not an unusual circumstance. This makes the case, based on the theory of last seen together, very weak in absence of motive. Now we come to the evidence of recovery of the weapon of offense at the instance of the appellant. The first witness to the recovery memorandum under section 27 of the Indian Evidence Act 1872 is PW2. In the examination in chief, he said that he was not aware who told the police that the knife was lying in a particular place. He stated that the police had said they were trying to find out the place the accused was telling. He stated that soil and knife were recovered from different locations. He stated that he signed on papers on which something was written which was not read over to him. He further stated that he was illiterate. PW4 Arjun stated that the police personnel had taken them to the place where the knife was found. The witness said that he saw the knife first and thereafter the police picked it up. He stated that he was not aware who had told police that the knife would be found at that place. On plain reading of the evidence of these two witnesses, it is apparent that the recovery of the knife at the instance of the appellant has not been duly proved. They have not stated that the discovery was made from a place disclosed by the appellant in their presence. Moreover, memorandum recording the statement of the appellant has not been duly proved. So, one part of the chain of circumstances has not been established. PW7 stated in the cross examination that he had gone to the place of incident. He stated that there were pieces of glass lying there. He stated that the pieces of glass may be of the light of a motorcycle. He stated that he had informed the police that the deceased may have sustained injury due to an accident involving a motorcycle. PW15 is the doctor who performed a postmortem of the body of the deceased. In the cross examination, he admitted that if the glass pieces were small and sharp, the injury sustained by the deceased could have been caused by small pieces of glass.